again, we are going to look at rights of employees. And the key word here is employees. And when we drill down, you understand that there are many workers, but not all of them have the same level of protection under the law. We will be looking at, under the circumstance of COVID-19 pandemic, what could the rights be, and could those rights be varied in any way to the detriment of the employee. We then look at remedies that are available when there are certain treatments meted out to employees by employers. And in terms of if you want to bring action, how long it should take for that to
lawyers, sorry to interrupt. If you can hear me, the voice is a bit low. So the listeners and the viewers are complaining that if you can raise a bit of your voice, that will really be helpful.
Thank you very much. Yes, so as I was saying, today we are going to look at rights of employees in a COVID era. We are in a pandemic. We've been in this situation for almost 2 years. Most people have had their employment rights jeopardized. And we're looking at what could be done under the circumstance. What can employers do and what cannot be done? We'll also be looking at which category of workers will qualify for such protection under the law. And if you have been in that situation, what can you do in terms of remedies and whether those remedies should be pursued in the first place? So today is all about employment, and our focus under the law will be the Employment Rights Act 1996, which is a piece of legislation promulgated by the UK Parliament, and that operates within the jurisdiction of the UK. But there are aspects of the discussion that would be beneficial to other listeners in other common law jurisdictions or countries. So the basics will apply to everybody, and the area of law that is applicable, as I said, will be the Employment Rights Act 1996, UK legislation. Now, we have mentioned three things. We're looking at employees, we're looking at workers, we're looking at self-employed, and we're looking at employment. So we know that employment is an activity that or contractual arrangement between two parties where one will be working for the other for the benefit of both, and they ought to give each other some level of consideration in terms of pay or in terms of price. Now, within the law, we will want to look at what the law says in terms of these categories. Let's start with workers. So everybody is a worker, and therefore under the law, section 233, Section 230, subsection 3 of the Employment Rights Act 1996 will tell you that a worker is someone who works under contract of employment or who works for others, and those people who are receiving the service from that worker are not clients or customers. So you can see that within that we have some workers who may be working for other people, and those people may be their customers or clients, and some workers who will be working under contract of employment. So that takes us to the two pathways: those under contract of employment, employees, and those who are not under contract of employment, where they are performing a service to their clients or to their customers, and we will largely call those people self-employed. Now, who is an employee? An employee under the law, section 230, subsection 1 of the Employment Rights Act 1996 will tell you that an employee is someone who works under contract of employment. And here we also want to know, what do we mean by contract of employment? So we'll go back to Section 1 of the Employment Rights Act, 1996, and that will tell you that a contract of employment should contain statement of particulars of employment. And those particulars of employment will determine the terms and conditions under which the employment is constituted or the contract is formed. So Section 1 will have a breakdown of list of things that we want to see. And those things will show that there is contract of employment in place. For example, there should be a written piece stating your role, stating your name, stating where you will be working, stating who you are going to work for in terms of the employer, stating the piece of activity or the specific things you will be doing, stating salary or wage, stating how long, stating so many other things, including procedures. And again, it will tell you that some of these can be deferred to a certain time period, but not too long. And again, some of these things can be at a particular location where the employee or the worker would be asked to have a look or to refer to. For example, the particulars of employment or the contract of employment will not have all the procedures. For example, procedure to do with health and safety, procedures to do with disciplinary, procedures to do with punctuality, procedures to do with competency or how you carry out your work with the level of skills required, and so many other policies that may be in place. Therefore, the employee will be referred to those other pieces of information. So that will be signposted. But what we are saying is that there should be clear terms and conditions underpinning that contract of employment. And that is under Section 1 of the Employment Rights Act, 1996. So we know that an employee or self-employed are both workers, depending on how they approach their activities with their respective employers or their respective individuals or organizations that provided the contract. So let's try to differentiate between employees and self-employed, because it's all about work. And therefore, there is a very fine line between employees and self-employed. So when matters arise, we want to define the status of the individual who is making a claim. So case law will be relevant under the circumstance. So I will take you to case law, and this case law is applicable to viewers and listeners from other jurisdictions, because this is a common law case law. Now, we are looking at the case of Ready Mix Concrete Limited versus Minister of Pensions and National Insurance. And this is a case that was adjudged, or that was promulgated in 1968. So you can see that it's a fairly old case, but very relevant. I'll also take you to one of the most recent cases, which is the case of Uber BV versus Aslam and others. And you can call it the Uber case. And this is fresh. It was promulgated February 2021 by the UK Supreme Court. So you can see that either going back to 1968 or coming down to 2021, the case law will still apply to our discussion. So we are looking at what does the case law say of who an employee is or who a self-employed person is. So the case law looks at some tests. The first test is that the person or the worker, because the worker is the middle ground. And once you move towards employee direction, you are an employee. You move towards the self-employed direction, you are self-employed. So how do we know that this person or an individual engaging in this contract of employment is self-employed or employed? In that case, employee. We know what the legislation says in terms of Section 231 and Section 233. Case law says that these tests must be present, or factors must be present. The first factor is that for somebody to be working under contract of employment, in other words, an employee, the person must be performing the service or must be working themselves, must be doing the job themselves, what we say personal service. Are you performing the role yourself, or you can ask other people, let's call them substitutes, to perform the role for you? If you have to do it yourself, then it appears that your status is structured or framed within the employment contract or your contract of employment, which states that the job must be performed by Mr. A and Mr. A only. We also move into the next test, which says that there should be mutual obligation to give and to perform a role for the person receiving the service or the organization receiving the service and by the person performing the service. So what we are saying is this: mutuality of obligation means if I'm an employee, then my employer can give me work to do or will give me work to do, and I have the obligation to do the work. So the employer's job is to give me a job, and the employee's job is to do the job. If the job is given, you cannot give excuses which are not merited or which are not tenable under the law. And the employer cannot also say, I don't have work for you, and therefore you can't not work for whatever reason. So there's that mutual obligation. Give me work to do because the contract says you must give me work. Do the work I have given you because the contract says you ought to perform your duties as stated in the contract. We move on to the next level or test, which says that there should be a level of control to determine that the employer has more control than the employee. In this case, what is the level of control? Who dictates or who literally directs the affairs under the contract? If the employer is the one directing the affairs and the employee has minimal control, then the person will be deemed to be an employee because the employer has high level of control. There are also other factors. For example, how is the pay given? Your salary, are you paid under PAYE, pay as you earn, or you are paid under the provisions of invoice so that you raise your invoice and you get paid? In terms of national insurance, do you pay your own national insurance as an independent worker, or the person who has given you the contract or service has to pay the national insurance for you? Are taxes deducted from the money you are getting or the pay under the contract? So if all these matters are present, also, are you required, for example, to follow the procedures in place at the workplace or under the service, policies and procedures, training arrangement, uniform regulations, and any other policy in place? Or you can decide to follow your own procedure based on the service you are performing for the client or the customer. In this case, if all these factors are present, you are performing the service personally, you are doing it yourself, nobody can do it for you. And even if you are sick, you cannot necessarily bring somebody from outside to say that this person is coming to do the job for me because I'm not available. Again, can you accept or decline the job that is given to you without any cause? Again, the level of control, is it so high that the employer is seen to be the person or the individual dictating or the party dictating the pace? And if you are paid through the PAYE, you have to pay NI or NI is deducted. You have to follow all the policies in place and so on and so forth. You have to wear certain uniforms depending on the type of job you do. And if you don't, you can be penalized or you can be taken through disciplinary. Then we are saying that you are an employee. So worker, employee, or employee, worker. If these factors are not present in your circumstance, then you are self-employed. So in the case of Uber, Aslam and others were drivers, and they felt that everything that is happening under the contract they have or the arrangement they have with Uber company suggests that they are more employees than self-employed. So they made a claim to ask the court to make a declaration to determine their status. The case had actually been taken through the various systems or tiers, right from the tribunal level, appeal court, and of course, the Supreme Court. And finally, it was declared that Aslam and others, under the circumstance, can be said to be employees because Uber company controls how the services are rendered. So you have the app controlled by Uber company. The driver will pick the job. The driver must be at a particular location to pick the passenger. The driver cannot decline without any due cause. Otherwise, Uber company will question them and sometimes terminate the arrangement. So you can see that most of these things go or gear towards employee status. The drivers have to file their self-assessment tax returns, have to do things to suggest that there is no PAYE system. However, so you can see that within the Uber case, they have two dual roles. Some have employee status, and at the same time, they can have the worker or self-employed status. And so some employees at the moment working for Uber or working with Uber are classed as employees, and Uber has to treat them as such in terms of the rights we'll come to. Now we look at the rights. What are the rights that you have as an employee? And you can see that the rights under the law will be much more than that of self-employed or those who are working, but with the proviso that the employer or the person receiving the service will not have high level of control or will not treat them as employees. The first one is what we have already mentioned under the law, Section 1 of the Employment Rights Act 1996 says that you have the right to be given statement of particulars of employment. In other words, you must be given employment contracts if you are an employee. If you are not an employee, then the arrangement in place orally or in writing determines how the service will be provided and for how long. And there will be some instances where the person receiving the service, i.e. the client or the customer, can decide not to continue or can decline future services, provided there is no fixed duration. Now, we move on to Section 13 of the Employment Rights Act, 1996, which also gives another level of right to employees. It says that employees have the right not to have deductions that are wrong made by the employer from their wages or salaries. So wrongful deductions from wages cannot happen under the provisions we have cited. We also move to Section 94 of the Employment Rights Act, 1996, which states that an employee has the right not to be unfairly dismissed. Now, dismissal is possible depending on the circumstance, but unfair dismissal is not possible because the employee has the right not to be unfairly dismissed. So the question is, what are the various things under the termination arrangement that are allowed in law? Let's go to Section 95 of the Employment Rights Act, 1996. And it will tell you that dismissal or termination can happen by the end date of the agreement. So if you have fixed contract and the contract has ended, then by the fact that the contract has ended or the arrangement has ended, there is automatic termination. So the employer can then ask you to leave because the contract has ended. It was a fixed term arrangement. Or the employer can dismiss you summarily because you have breached certain aspects of your contract in terms of your conduct as an employee. So breach of your contractual agreement in terms of your conduct. So where there's gross misconduct, then that will give grounds for summary dismissal under Section 95 of the Employment Rights Act. Now, the employee can also decide to terminate. And the termination will be where, of course, you have given notice that you want to leave, because the contract will specify the notice period. So you work your notice and you leave at that after the end or at the end of that notice. You also can terminate the arrangement under what we call constructive dismissal. In other words, you can decide to leave or terminate the arrangement because of the behavior of the employer. So if the behavior of the employer makes your presence untenable or the environment becomes less conducive for you, then you can leave and cite the reason to be the behavior of the employer or employer's agent. That is constructive dismissal. Now, you can still bring an action against that employer because your leaving was necessitated by the conduct of the employer. We also have wrongful dismissal, where the employer terminates your contract or arrangement without following due process. And due process, for example, will be that they have to give you notice, and that notice was not given, or you are going to be made redundant, and the process of redundancy have not been followed through, or there has been what we call transfer of undertaking and protection of employment arrangement under the 2-pay provisions. And because of that transfer, you have been asked to leave without any due reason. And the reasons will be that there is economic, there is technical, or there is organizational reasons why you cannot be maintained. for example, the situation is such that it is not economically wise for you to be maintained. In that case, you have to be paid off, which is redundancy payout. Or we have organizational reasons, as I said, downsizing and other important reasons. Then you have to be given your redundancy payout. Or we have technical reasons such that the company's provisions are such that you will require some level of technical skill, knowledge, or understanding to perform your role. And for such technical reasons, it will not be appropriate or necessary for you to remain. Then, of course, you will be asked to, the contract will end, but you have to be given your redundancy payout.